Good afternoon. My name is John Payton, and I am a Justice of the Peace here in Precinct 3, Place 2. If you are in the Allen Independent School District, then this video was made so that you can have better understanding of what the new laws are here in the state of Texas in regards to parent contributing and now the new law called Truant Conduct. Today we are going to talk about the elimination of failure to attend school as a Class C misdemeanor charge for students not attending school, and the replacement with Section 65, Title III of the Family Code, which is now being called Truant Conduct. It's been an interesting response that I've received from students when they tell me that they have received their information via text from their friends or on social media in regards to what's gone on with truancy. I've had answers that have been as crazy as there is no more requirement for students to attend school here in Texas, to now you can put us in jail for 2 or 3 years, to all of our cases have to be expunged and we can never be filed on for truancy again, but yet we're required to go to school and the school has to do more. So today my plan is to try and help shed some light on what the new law actually says and give you my interpretation of Section 65, Title III of the Family Code. This is all going to be under House Bill 2398. The idea was to eliminate a criminal charge against the child, never to get away from the fact that a child is still required to be in school in the state of Texas. Sadly, and most interestingly, a lot of that is driven by funding. If the federal level doesn't have a requirement for a state to require their children to go to school, then the federal U.S. Department of Education won't fund the state of Texas's Department of Education. And so that requirement is still going to be in place so that the state can receive funding from the federal government to help fund education in the state of Texas. With that being said, failure to attend school charge did go away. In fact, as of September 1st, 2015, all documents, all case files, everything that ever existed in regards to a failure to attend school case has been and is being expunged from the child's record. Now, moving forward from September 1st of 2015, all the new charges will be called Truant Conduct. Truant Conduct is defined as a child engaging in truant conduct is required to attend school under Section 25.085 of the Education Code and fails to attend school on 10 or more days or parts of days within a 6-month period in the same school year. Truant conduct may be prosecuted only as a civil case in truancy court. Now, interestingly enough, this is still a charge. The allegation is truant conduct. The charge is truant conduct. You will not be entering a plea of guilty, not guilty, or no contest. You will now, if the prosecutor, the state prosecutor that prosecutes criminal cases, finds that the evidence that they have been given by the school district is sufficient, shall file a petition creating the allegations against you called truant conduct. When that petition is filed, that's when the entire process of the adjudication hearing begins. Prior to the adjudication hearing, the school district must enter into truancy prevention measures. Now, the law doesn't say that they have to enter truancy prevention measures if you're going to be uncooperative or if you're not going to show up for your meetings or your hearings. They have to make a good faith effort to make sure that they have tried to implement truancy prevention measures to prevent you from having to come to truancy court, which, by the way, is something that I have preached for 25 years of being on the bench. That's why we provide videos like this, educational videos, to hopefully educate and inform so that you'll make good decisions and not find yourself going into a courtroom. However, under the truancy prevention measures, these are measures that are now required on student cases. As a truancy prevention measure, under subsection A, a school district shall take one or more of the following actions. The majority of the school districts that I have spoken to in Collin County, and really a part of our Collin County truancy uniform policy, most school districts are electing to choose option 1. Number 1, impose a behavior improvement plan on the student that must be signed by an employee of the school that the school district has made a good faith effort to have signed by the student and the student's parent or guardian, That includes a specific description of the behavior that is required or prohibited for the student, the period for which the plan will be effective not to exceed 45 school days after the date the contract becomes effective. And again, almost all of the school districts that I'm aware of and our Collin County Uniform Truancy Policy Committee has decided that they wish to use and elect to use the first option. So be prepared to have to come into a meeting and sign a BIP, or what I've explained to students and parents, what used to formerly be called an attendance improvement contract, which fortunately all of you who are students in Collin County have probably come across, because most of the school districts here in Collin County have used attendance contracts to help you improve your attendance and hopefully not lose credit in your classes. Don't confuse the 90% rule, where you're required to be in school 90% of the time, with truant conduct. They are not one and the same. If you make your unexcused absences or excused absences up, that is with the 90% rule granting you credit back for your classes. However, if you make up your unexcused absences or parts of days, it doesn't mean that you still haven't violated the law and could be filed on for truant conduct. It just means that you've received your credit back, especially for secondary students. So the two are mutually exclusive, although they do have a tendency to bleed over to one another. Furthermore, the age has changed. A lot of students have come in and said, well, we can drop out of school now at 17. I don't have to go to school anymore, and I'm not getting my GED. I've actually had students tell me that here in court. However, that is not the case. You are now required to go to school till your 19th birthday. If you are filed on and you are under court order during the duration of your 19th birthday, the court order doesn't expire because you've turned 19. You will be required under the remedial order to continue to attend school through your 19th birthday. And if you've not turned 19 before the school year starts, you will be required to attend school and begin the school year. And so those rules have changed and bumped up the age of requirement to attend school one additional year. Furthermore, now, once a case is referred to the truancy court, it is sent over to the prosecutor. The prosecutor in Collin County will review it within 7 days. If there is a holiday, or if there are other days where there are ice days or weather days, that may be extended by 2 to 3 days. However, under the Collin County Uniform Truancy Policy that we've already discussed in Collin County, every 7 days, a county or city prosecutor will review the petition or the referral made by the school district to the court. Once it's referred and looked at by the state will send it back to the court, approving it or not approving it. If the state says the petition doesn't have the required elements, then the state will dismiss it and nothing will go forward. The school district will continue its process. However, if the state says, yes, there's enough elements here to prove the petition to be filed, then they file the petition. You will receive either a certified mail return receipt requested letter summoning you to court, or you will be served by a deputy with a paper at your home place of employment. Or really, it doesn't say that you can't be served at school, if that's where they can find you and finally get you served. I can tell you that from a county standpoint, sending out certified mail return receipt requested is not profitable. And I don't mean profitable from making money, but it takes away from the taxpayers' money. And so therefore, we're going to more than likely have all of ours served by a deputy. So the deputy will go to your home, knock on your door, serve both you, the student now, and the parent, and any other person that may be contributing to your lack of school attendance. Under the new Truant Conduct law, they have added a section that if there is a determination that somebody else is contributing to your truant conduct, that person can now be brought into the court and placed under court order as well and be served. Let me give you an example, because this is the most common. Students turn 17. For whatever reason, police departments have told them that they can move out of their home, that they're grown, they're adults now. That is not the case. Both under Acton, which is a Supreme Court case from 1995, and under state law, a student doesn't become an adult or the age of majority until they turn 18 years of age. So if you leave your home at 17, a parent has a duty under section 151.001 of the Family Code to go out and retrieve you and bring you home. Feel free to review that online at www.tx.gov and look up state statutes, and you can find that statute there. Because I know students like to go and find their own proof. They're great researchers. So go out, find that so you understand what the law says. So at 17, you move out of your home and move in with a boyfriend or a girlfriend and their family. If you do not have permission from your parents to do that, then you are violating the law. That person, if you have truant conduct, can then be brought into court and also be placed under a court order. So do understand that you are now implicating other people in this process if you have truant conduct, and they can be placed under court order as well. That is one of the big changes to the law. So, we've gotten you served, the referral's been made, you show up to court. Once you show up to court, there will be a waiver of rights that will be read to you. You will be explained your charge in great detail. You will be explained your appeal rights in great detail. And then you will be asked if you wish to answer to the petition true or not true. If you answer to the petition true, then we will go forward and issue a remedial court order. For the most part, Article 45054, which was the old law for failure to attend school, and all the requirements that come with it are folded into Title III, Section 65 of the Family Code. The court can still order community service. The court can order you are required to attend school. The court can order you are required to attend tutorials. The court can order that your driver's license be suspended. The court can order counseling. The court can order classes. The court can order treatment, whether it be inpatient, outpatient drug treatment. So all of those things have not changed, and the remedial order can still be put into place as the old order did. Then there becomes the question, well, I don't want to do anything you tell me to do. And that, of course, is clearly up to the student. At that point, we can hold an enforcement hearing, we can hold a modification hearing, which if you've been in court with me before, you know those are called status hearings. And then at those hearings, if we determine that your behavior is contemptuous, we can hold you in contempt and fine you. At that point in time, also modify your court order for other conditions to help promote good attendance. If you continue to violate your remedial order, at another hearing you can be held in contempt of court again. If you get held in contempt of court a second time or a third time, you will be referred to the Juvenile Probation Department, where the juvenile probation officer can do one of several things. One, institute new conditions and then pass you back to the court. Two, refer you to the district court in Collin County, where you will then go in front of the juvenile judge. At that point in time, there will be an attorney appointed for you. Also at that point in time, the district judge will notify you that in fact you could be looking at a possibility of incarceration. And that means jail. At the level of the district juvenile court judge, it isn't just a weekend possibility. The juvenile district court judge at the hearing, in fact, must tell you what it is that they can or cannot do if you do not act accordingly and follow your court order. If you get referred to the district juvenile court, these are the things that can happen. The juvenile court finds that the child engaged in conduct that constitutes contempt of the order issued by the truancy court or direct contempt of court. The juvenile court shall enter an order requiring the child to comply with the truancy's court order. Number 2, forward a copy of the order to the truancy court within 5 days and admonish the child orally and in writing of the consequences of subsequent referrals to the juvenile court, including a possible charge of delinquent conduct for contempt of the truancy court's order or direct contempt of court, and a detention hearing. A detention hearing means that you could be looking at going to the juvenile jail. If you end up in the juvenile jail, the district court judge will inform you that that could end up in a sentence for up to 1 year. And so really, the advice I would give you as a student would be to A, not have poor attendance, make good decisions, reach out to your crisis counselor, to your house principal, your sub-school principal, your assistant principal, reach out to your counselor at your school if you are having difficulties that is preventing you from being able to go to school, so that they can assist you in trying to get past those things and get into a better rhythm with your attendance. Furthermore, the court will explain to you that you have a right to a jury trial. That's part of your waiver of rights. And then the court will also explain to you your right to not have to say anything in your case that could possibly put you in a bad spot, and allow you to address all the witnesses that are saying that you have done these acts of truant conduct. So those are some of the things that the new law has done. However, what you have found is that the new law did not remove the requirement to attend school. It did not take away the fact that you can be placed under a court's order and be required to do all of the things that would help you be a better student and attend school on a regular basis. I recommend that if you have any questions, again, go to the website for the state of Texas at www.tx.gov, type in Texas statutes, look up Section 65 of the Family Code under Title III. You want to start on page 30 of the bill, because that's where the bill runs, and that's where it all begins for you. If the court finds that you are not being represented properly, the court will hire for you a guardian ad litem and charge that off to your parents. Well, where that person will advise your parents how to parent you. If the court feels that you are not being represented properly, the court can also hire you an attorney and charge that off to your family as well. The idea that you don't have to do community service anymore is not true. The court can now order that you and your parent do community service as well, up to 50 hours. So these are the things that have changed, and these are now the requirements under the new law called Truant Conduct. So I do recommend that if you get to 3 unexcused absences in a 4-week period of time, and you have to sit down and go over the BIP with your school, please adhere to those recommendations so that you don't hit 10 unexcused absences or parts of days in a 6-month period of time. If you have any questions, please get with your local school officials, and they are more than happy to answer those for you, or feel free to email my court, and we'd be more than happy to set up a meeting to answer any of those questions for you as well. I hope that this is beneficial, and I hope that it has been able to provide you with information that has otherwise been kind of skewed by all the text messaging and social media. Thank you, and I wish you the best of luck in this new school year.